All right, we started a new tradition last week. We're going to be interviewing from here on out nothing but celebrities. We had Dan Aykroyd last week. And so I'm thinking, how do I match that? What level of celebrity can I attract to the program to keep this momentum going? And I found one. Katie James.
So honored.
Katie James, who is a celebrity lawyer, in my view. Now, I speak only for myself here, but if you go to carwreckkatie.com, you will see exactly what I'm talking about. I can't say Katie is the best personal injury lawyer I know, because I know a lot of really good personal injury lawyers, and I don't want to hurt anybody's feelings. Not that anybody cares what I think on that front, but she's astoundingly good. I've seen her work. I'm telling you, she was the first person I thought of after Aykroyd, because this area of the law is fascinating to me. It's not an area I practice usually. I've done it before. I don't want to disclaim all knowledge. I have done personal injury before, and I'm willing to do it again at bergpc.com. If you're interested, you want me to look at your case, Berg, B-E-R-G, PC.com.
My Lord Jewish.
bergpc.com. So we do some of that, but I am no expert. That's why I had to have Katie James of the James Law Firm from here in Houston on the program. And welcome to you, Katie James.
Thank you. I'm so glad to be here and to talk about personal injury and jury trials and all the stuff that goes into that.
Hold on. Before we even get started, I have a question for young Evan. Young Evan, we have previously, surreptitiously, unbeknownst to me, been video recording these things. Are we doing this today?
Yes, sir. Yes, we are.
I mean, I feel, look how dressed up Katie is. And she's dressed respectfully and formally as if she's presenting herself in public. And I look like I'm getting off the bus downtown on Pierce. What is it? Are we recording this really visually? Video recording?
Yes, I can confirm video is being recorded.
All right. So now that we have that out of the way, I'm going to need to go get some different clothes.
You look great, Geoff.
I appreciate that. I'm not necessarily public facing ready looking like I'm a lawyer. I'm promoting my law firm, and I look like I'm getting ready to compete in the X Games.
You're good.
All right. Well, in any event, let's focus on you.
Okay.
Because I have seen Katie in action. This is just a lawyer I have a tremendous amount of respect for. So let's talk first. Katie James, Houston, James Law Firm. What made you want to get into personal injury? Plaintiffs, specifically plaintiffs' personal injury. I think that's 100% of your practice, isn't it?
100% of our practice, yeah. Man, well, I'll tell you, I didn't want to do that when I first went to law school. I think like everyone, I wanted to be in the top 10%, and I wanted to go into big law and make, I think at the time that I graduated, it was like $125,000 a year. Like that was the goal as a first-year associate at big law. And then won out, first-year law school finals came around, and I was not in the top 10%. But I was really good at mock trial and moot court, and that's what I loved. I liked being in front of people and talking and, being in front of juries. I mean, not a real jury at that point, right? But mock juries. And so I thought about working maybe for the DA, but then I realized I didn't want to do criminal law. And then I clerked and worked at a personal injury law firm in Houston and fell in love with it. Fell in love with being in front of juries and like actually helping clients.
This is not to call you a stereotype, but it is a stereotype. It's almost a trope of plaintiffs' personal injury lawyers. Terrible students, astoundingly good trial lawyers. This is like a thing that lawyers just know. And you happen to fit, apparently, right into that category, because I have seen you in court and can affirm that you are quite gifted in the courtroom. although I have no knowledge of your grades other than what you've just disclosed to the entire planet.
Well, hey, my grades weren't that bad, but they weren't top 10%, right? And I think, I don't think most people go to law, and I could be totally off base here, but I don't think most people go to law school wanting to be a personal injury attorney. Like, at least for what I experienced and the people that were in my law school class, that wasn't it. Everyone wanted to go work big law, be in the top 10%. And it just didn't work out. And I was devastated. Like, I remember that summer after my first year of law school, just being like, what? Like, my plan didn't work out. And 90% of the other kids in my class probably felt the same way. But in the end, geez, I am so happy with what I'm doing now. And the fact that I don't have to bill by the hour is nice.
This is something that we've, of course, talked about repeatedly on this program, is the excruciating life force reducing exercise of recording every minute of your day. It's just a fact of life for most lawyers. Plaintiff's personal injury, there is no way to recover attorney's fees. We'll talk about that in a little bit. For someone who's been injured and needs a lawyer, how they can think about fees. We can get to that especially if you remind me, because it may be something that I forget. But for most lawyers who do commercial trial work, all lawyers who do commercial trial work, recording your hours it just becomes muscle memory and something that you must do. It's very nice to hear from people who don't have to do that and hear about how much happier their lives are. So you gravitated at some point toward plaintiff's personal injury. You didn't want to do criminal work. You decided to do plaintiff's personal injury. You said you worked for a PI firm. Were you able to get some trial experience early on doing that?
Yeah. So the firm that I worked at was always going to trial. So that was, how I first started going to trial and doing PI work. But I haven't just tried PI cases. I've also worked on first-party home insurance cases. So a lot of wind and hail claims. Not as exciting as a car wreck with a bunch of chiropractic visits. And, that's a little juicier and more exciting in front of a jury than having to sue an insurance company over them not paying for your roof after a hurricane. A lot of those cases were in federal court down in the valley that I worked on, and it was great. But I think my heart is in the car wreck cases.
So you developed this passion for representing people who have been in car wrecks.
Yeah.
Is it? Go ahead.
Go ahead. No, you go.
So I guess the first thing that comes to my mind is especially if I'm not a lawyer, if I'm a layperson or someone who's been injured, is the first thing you ask whether the wreck was your fault? Whose fault was the wreck? Who got the ticket? Who did the officer on the scene determine was at fault? That's the first thing that comes to my mind.
Yeah, well, let me start by saying the officer doesn't always get it right. Because the officer is never there when the wreck happens, right? So all he or she is doing is talking to usually the two individuals that were involved in the crash. And we never call it an accident on the plaintiff's side because there are no accidents. It was a crash or a wreck. That's something that I've kind of had to change, since I've been practicing. The first time I said accident in front of a jury, I cringed, and now I try really hard not to say it.
Well, so explain why that is. I've never thought about that before because I don't try these cases, but obviously I now see why. Explain why that is.
Yeah. Because accidents happen, right? Everyone knows that phrase, and a lot of times the defense attorney for the insurance company will get up in front of the jury and say, this was just an accident. But there's nothing accidental about being on your phone and texting and driving and rear-ending the car in front of you, right? Or failing to stop at a stop sign. Like, the reason accidents or crashes or wrecks happen is because someone wasn't following the rules. Someone, was on their phone. Someone was driving too fast. In my practice, I've handled thousands of car wrecks. Right now, we've got close to 300 clients, the majority of which are car wreck clients. In none of those cases was it just, an accident. Like there's someone you can fault and a reason why you can fault them.
Okay, so when you first get one of these cases, is the first question you ask or attempt to determine whose fault it was?
I mean, if someone's reaching out to me and I'm a plaintiff's personal injury attorney, usually they don't think they're at fault, right? But yes, of course, I'm going to look into that, right? I'm going to look at the police report. And if the police report faults the potential client who's coming to me, I'm going to, that's kind of a red flag, even though, like I said, the police report is sometimes wrong. But yeah, definitely that's the first thing you look at is whose fault it was. And if it wasn't, the potential client's fault, you look at that. And then the next step is to look at, were they hurt? Do they have damages here? Because no matter, if your car was totaled but you weren't hurt, you are going to be hard pressed to find a personal injury attorney that will represent you.
If you have no physical injury.
You don't have physical injuries, which is, a really, it's not good for, Texans, or that's where I practice, right? The reason why is because what ends up happening a lot of times, or I'll have potential clients call me and say, look, my car is totaled. The at-fault insurance company is denying liability, but I'm not hurt. And then I tell them, I could file a lawsuit for you, but I'm going to take a cut out of what the value of your vehicle is. And it just financially doesn't make sense for me to take the case.
Well,
Client will never be made whole.
Right. So that would be a good jumping off point to talk about fees, how you address fees in these cases. 100% of your work is plaintiff's personal injury. That means you're doing everything, I assume, on a contingency basis. Is that right?
That's true. Yeah. So you see these like billboards and commercials for attorneys, and I don't get paid unless you win too, right? Or I don't get a recovery unless you get a recovery. It's true. I take a percentage only if I'm able to get money on behalf of my client. And yeah, that's how it works.
And so the idea is that they're being compensated for their physical injuries. And how badly does somebody need to be? What if they think, I was in a wreck, somebody T-boned me, my car is totaled, and I was really freaked out. And thank God I came out of it and all I had was a scratch. But I was really upset. I couldn't sleep for a month and my heart rate is elevated. I've got all this anxiety now. Is that an injury?
Yeah, so you can make a claim for mental anguish, physical impairment. There's a whole list of different damages that you can claim. I will also say that there's a direct correlation between how damaged your vehicle is and how much money the insurance company is going to pay you. If your car got totaled, you're going to get paid more by the insurance company. That's just how it works, even if you weren't that hurt, versus your car is, has a couple scratches on it, but you went to the emergency room and you're having terrible anxiety from the wreck. Even though there's not a lot of damage to the vehicle, the insurance company's not going to pay you as much.
Is that because of the visual impact that it has
100%.
In front of a jury?
Yeah. And so there are some attorneys, and I'm one of them, that if there are photographs of a vehicle, and our client's vehicle, say, and the photographs don't look bad after the wreck, right? Maybe there's a scratch on the bumper, or it just doesn't look like the car was really hit. I will file a motion with the court to not let those photos come in front of the jury as evidence. Because the last thing I want the jury to do is to look at those photos and, say, oh, well, why did they go to the hospital and that bill's $20,000? There's no damage to the car. And you can hire accident reconstructionists and engineers to say, like, even if there's not a lot of damage to the car, you can still damage, the person that's in the vehicle. They can still be damaged from the wreck.
Sure. But if you're filing motions to keep that evidence from the jury to pictures of the barely damaged vehicle or something that's clearly going to hurt your chances with the jury, I would think, if I'm the judge, I would think, Katie James, you were in this court 3 weeks ago trying a case where the car was totaled, and you could not argue more forcefully that the pictures must be shown to the jury. How do you argue the reverse, the converse of that, and how often are those motions granted?
So it depends on the judge. That's what it boils down to. Some judges will require an expert to have the photos be evidence in front of the jury. And there are certain things that lawyers can do in order to always get the photos in front of the jury, right? Like if you make a property damage claim. So, and a lot of times I'll make a property damage claim when I want the photos in, because that way it's relevant. If I don't want the photos in, I'm not going to make a property damage claim because the photos would be relevant for that. Attorneys can file certain motions or make certain claims in order to try and keep those photos in or out.
So it just depends on the judge. We're in Houston, Harris County, Texas. We have a lot of judges in a big county like this. We've got a lot of judges. So now's your opportunity to discuss which ones are good and which ones are bad. Was that not something you wanted to
No.
do? We not talk beforehand that we were going to get into this? So why we have you on the program today? No?
Yeah, that would make for some good content. But nah, I'm good. I'll keep that.
You can't blame me for trying. All right. So let's talk. Let's do that. Let's talk about not judges,
Okay.
but jury trials. And in fact, some judges do enter into this a little bit. But since I try crypto cases and commercial cases, I would think that the entire approach is different because everybody drives to and from work. Everybody can relate to someone who has been attacked, literally suffering in the integrity of their body. I mean, everybody can relate to that. When you try a commercial case, you have to analogize to get people to relate, because people aren't spending all day thinking about commercial paper or something.
Yeah.
So it's a very different approach, I would think. Do you have an overall or a general theory of jury trials as it relates to, let's focus on car wrecks, car crash? What's the word I'm not supposed to use? Accident.
No accident.
All right, carwreckkatie.com. What is so when you try these car wrecks, what's your overall approach? If you have one.
Well, I don't know that I have one, but picking a jury is probably the most important part, because you get one bad juror and your jury could be ruined, right? One bad seed. So picking a jury and the types of questions that you ask jurors, and attorneys have probably heard this a million times, but you're not selecting jurors as much as you're deselecting them, right? So you're trying to figure out who you don't want on the jury during voir dire, and hoping that the judge will agree with you for whatever reasons, right? And getting them off the jury. So I'm mostly looking at jurors that will award money for pain and suffering.
So is that how you focus your voir dire, or as we mispronounce it in Texas, voir dire? Is that how you approach it?
Yeah. So I'm asking questions to see if people would be able to award money for pain and suffering. And surprisingly enough, a lot of people, can't award money for that, or they say they can't, at least. It's rare that you've got potential jurors that say that they can, and are like very adamant about that. But yeah, I've had a lot of time, a lot of potential jurors raise their hand or their placard saying that, I think, life happens, accidents happen. And, if they're having anxiety or depression from, the fact that they got their leg amputated as a result of this wreck, that's just part of life.
And that's not compensable by money damages. So people think these things, and that's just the way they think. And it's obviously you have to find that out before they find their way onto your jury. So what types of questions, I mean, you just asked directly who's not going to award money damages for pain and suffering and then go through the panel or
I mean, pretty much, right? And a lot of times jurors are shy. They might not be shy people, but they don't want to raise their hand or their placard in front of everyone. They just want to sit there and hope that they don't get picked. So part of my job as a lawyer is to entice people to start talking, because the more people talk, the more information I can learn from them, right? So one juror might raise their hand and say, I would have a really hard time awarding money for pain someone experienced. And so then my next follow-up question is, all right, how many of y'all feel similarly to the way, juror number 3 feels? And then you start seeing more hands or more placards go up. So that's kind of the idea, right? Get one person to start talking and then the whole panel starts talking.
Okay, so when you do voir dire, I mean, I happen to agree with you. This is, if not the most important phase of trial, it is up there. I've said on this program before how much lawyers think their closing arguments are the key to trials, and they're really just not.
No, the jury's made up their mind by that point. I mean, I think a lot of times the jury's made up their mind by the end of the opening statements, right? Because they've seen you for quite a bit at that point. They sat through voir dire, and that's a whole nother thing, how much time you get for jury selection.
So
because some judges will, let you, they'll give you 30 minutes to get up in front of the jury and ask questions. And when you've got a panel of 60 people and there's nothing you can do about it, the judge tells you how much time you get. And it's really hard to learn about 60 people or 30 people even in 30 minutes.
And you don't, the key to this is that you don't learn about them by you talking. You have to make them talk.
Yes.
And as you say, there are people who are just constituted in such a way that they will not speak publicly and are very reticent, nervous, or whatever, and do not want to express themselves in front of a room full of strangers where everything being said is taken down by the court reporter. It's very difficult to extract information, to deselect, as you point out. This is a process of elimination, and very difficult to find out this information. All right, so you approach it very directly. You ask the panelists who is not open, at least, if I prove my case, to awarding my client damages for pain and suffering or whatever else you want to ask. But if you're trying a car wreck case, here's what this is what I really want to know. Here, let me tell you how I relate to this.
Okay.
When I started, by the way, you said when you started, Big Law was paying like 120 grand.
Yeah, something like that.
Something like that. Yeah. When I started, it was 65. So just to give you a sense of the difference in look at Evan laughing. Evan makes his living mocking me because I'm so old. And he's so young and he has his whole life ahead of him. So I don't know why.
I take a lot of enjoyment out of this.
It's very sadistic.
Very, life-affirming.
Yeah, he sounds so passive and kind. He's just not. He's cruel. He's a cruel young man. So I don't want to apologize because you're the one that's constantly oppressing me. We'll talk about that. We'll talk about that in another episode. Evan and I have our problems. So when I started back before court reporters and everything else, when you're having to avoid, horse droppings in front of the courthouse and things like that, just to get in there.
Yeah.
I tried, I don't know how many criminal cases. I did something similar to what you talked about. The firm where I started did everything. We practiced door law. If it came in the door, we would probably do it. And that included criminal. So I don't know how many misdemeanor criminal cases. And the way that this worked was, and it was invaluable experience. I don't know how many cases I tried, But I would have, I mean, these were misdemeanors. So they were first DWIs or possession of marijuana or just things where nobody could get hurt. You try the case and nobody gets hurt, regardless of the outcome. But the files were not even a quarter of an inch thick, and just nothing, no pretrial, anything. You just show up and go do it. So if you've got, you said something like 300 pending cases, something like that.
Yeah.
You couldn't possibly, and I think you've got 3 lawyers at your firm now, right?
We do. Yes.
One partner who you can't fire.
Can't fire him because I'm married to him.
Well,
So, stuck.
and another a younger lawyer, both of whom are outstanding. I actually have dealt a little bit with.
Yeah, Markin is the other attorney at our office, and he's fantastic.
All right, so how do you prepare? How do you prepare for a car? You've got 300 cases, disparate facts. The devil is in the details of every one of these cases. If you have to go try it, you have to know that file backwards and forwards. How do you prepare?
Well, let me answer your question by not answering your question.
Don't think I won't object, but go right ahead.
Well, I'm mostly practice in Harris County in Houston, right? And your case in Harris County is set on a 2-week docket, which means the judge could call your case at any time during those 2 weeks. And if you don't get called to trial, your case gets reset. And there's a huge backlog of cases in Harris County. There's a whole lot of reasons for that. There's a lot of cases in general, Harvey, then COVID. And so it's hard for your case to actually get to trial. So most attorneys in Harris County that are doing car wreck cases are used to, not getting called during that 2-week time and then getting reset and reset and reset. And so sometimes you don't think you're going to be called for, a while. And I guess my point in all of this is you really never know when you're going to be called to trial. I've had experiences where the case has been reset a few times and I don't think I'm going to be going for a while. And then the day before a 2-week docket, I get a call from the coordinator and they're like, hey, you're going to be going to trial tomorrow. Show up at 8:30 so you can pick a jury. That's happened once in my career where I found out the day before at 3 p.m. that I was going to trial the next day, and that night sucked. It was awful because I'm sure I slept, but not very much, getting ready for the case. So I say that because it's rare that you know in advance exactly when you're going to trial, which makes it really hard for clients because my clients are just regular people with kids and school drop-off and work and other commitments. So when I tell them, look, you might go to trial anytime during these 2 weeks, they don't understand it at first. And then I have to go through this whole explanation. So in order to not be staying up the night before, there's a lot of prep work that goes into these cases that I know are going to end up going to trial before that 2-week docket even hits. So I take depositions before and I record those depositions with video so I can play them at trial if I can't get my witness to actually show up for trial because, it's so last minute. That's something I do. But yeah, you kind of never know when you're going to go to trial, which seems a little crazy.
Well, look, anybody who practices in Harris County, in Houston and Harris County, Texas, has this issue. It's not limited to car wreck cases. No. It's commercial cases too. You can ask for a preferential setting, but that, as you say, depends on the judge. That's court by court. Some courts will give you one. Some courts, just as a matter of policy, don't do pref sets. Anyway, I object as non-responsive to my previous question. We've already gone over this in previous episodes. Evan, what does objection non-responsive mean?
Oh no, another quiz.
It means he asked a bad question.
How dare you cheat? That's cheating. First of all, number one, you trying to cheat.
What Katie said.
That is wrong. Both of you are wrong. Get out, both of you. You're off this podcast immediately. So the question was, how do you, let's say you've got a case, you've got 300 cases. every one of these, and again, I attest to the quality of work that Katie James does, which is why I'm happy to give out her website, correctkatie.com. Now, if those are on average, say you've got average damages of what? What would you
Average medical damages are probably around $45,000 to $50,000.
Okay, let's say it's $100,000. An average of damages on your case is $100,000. Your time is valuable. You're taking somewhere between 30 and 40% of any recovery in all of those cases. That's how you get paid. That's how your firm gets paid.
Right.
How do you budget time when you are called to trial to learn everything there is to learn about that file, knowing you've got to try it the next day? Who is my ideal juror? Who is the person I'm introducing to the jury? What is it about them I really want the jury to know? And what are the very, very granular, specific details of the wreck that they were in that I must prove to the jury?
Yeah. So like 90% of my cases don't go to trial. I'll start by saying that, and that's just not me. I would say that's the majority of plaintiff attorneys, at least in Texas. Like the majority of cases don't go to trial. You get a vibe early on if your case is going to go to trial or not. So it wouldn't be fair to say like I'm expecting all 300 of these cases to go to trial, because that's just not true, right? I've got a handful, maybe 20 cases where I'm like, okay, these 20 cases, there is a good shot that these could go to trial. So I need to be intimately familiar. Not that I'm not with the other cases, right? But I really need to be familiar with these cases as they kind of gear up towards the end, because I'm banking on this one is not going to settle and it's probably going to go. So when you think about it that way, it's much more doable, right? Because you just have less cases than what's actually on your docket. But when it's time for trial, or when you're told that you're going to trial, that is all you think about day and night. I'm not working on anything else. And my office knows that. My family knows that. Like, I am gearing up for trial. The last trial I had was in Montgomery County. And I didn't even stay at my house. I got a hotel room because I just needed to be able to focus for, we thought it was going to be a week. It actually ended up in a mistrial. It's kind of an interesting story. But yeah, I didn't want to be bothered.
Well, wait, before you move on from that.
Yeah.
Because mistrials are very rare.
Yeah,
and
it was my first one.
It's your first one. So after years of practice, you just had your first mistrial. And a mistrial means something legally incurable has occurred during the trial, requiring the judge to just throw it all out and start again. Meaning someone has said something, someone has introduced some evidence that is incurable. You cannot tell the jury to disregard something. There's been a terrible error that requires everybody to go back to square one, pick another jury, and start all over again. Incredibly rare. In fact, I tried about a 6-week case in front of a judge in Harris County who you know and love, but I won't identify, who is I love this particular judge. And opposing counsel continued to ask questions, trying to elicit testimony that was excluded by a motion in limine. Not only excluded by a motion in limine, meaning an order entered before the trial that requires all parties to approach the bench and discuss admissibility of that particular subject before it can be elicited, kept violating this motion in limine. And it was over and over, and I kept objecting, and she kept sustaining it. And finally, we approached the bench, and I said, Judge, we've been at this, by that time it was 2 weeks or something like that. I said, we've been at this day and night. I really don't want to ask for a mistrial. And she said, oh, you're not getting a mistrial. That's how much judges do not like, they don't want to go backwards. So What happened? How did you end up in a mistrial, and who's the culprit?
So it was a car wreck case in Montgomery County. It was a case that was only supposed to take like 3 or 4 days. I have a really good relationship with the attorney on the other side. A woman that I really respect and admire, and I've had other cases with her, and I was really excited to try this case against her. So we picked the jury. Jury is in the jury box, and the first witness, or we do opening statements, right? Then the first witness is, I get to call the first witness, and I called the defendant. The defendant in this case was a man that was, I don't know, I don't want to misspeak, but like maybe late 70s. Obviously suffering from, I, again, don't want to misspeak if it was dementia or just memory issues, right? He clearly caused the crash. There was no question about the fact that he caused the crash. Even the attorney on the other side, like his own attorney, I believed that he caused it, right? So it was an issue about damages. But we still have to prove to the jury, that the wreck was not my client's fault and it was someone else's fault. Because at the end of the day, the jury has to fill out a charge and they have to first find that there was negligence by the other party to even award damages. So my questioning of him, I'm asking questions about whose fault was the wreck. And I kind of have a rough outline of the questions that I'm going to ask. And I usually stick to it, but for whatever reason, I didn't stick to it. And the last question I asked him was not on my outline. And I asked him, sir, do you take responsibility for causing this wreck? And his response was, well, my insurance company did.
Oh.
And so most people think that's a fine answer, but not in Texas. And the reason why is because you cannot talk about the fact that you have car insurance or that your attorney is, an employee of the car insurance company or has been hired by the car insurance company. And the minute you bring up car insurance, it's an automatic mistrial. And so I can't get up and talk about the fact that, this is an attorney for the insurance company and it's really the insurance company that's determining whether or not my client should get paid. So the minute that he said insurance company, it's an automatic mistrial. And so we both, myself and the defense counsel, approached the judge, and defense counsel felt horrible because she, like every attorney knows to do, told her client, do not talk about insurance, but it just came out. And sometimes that happens. It had never happened to me before. So
accidents happen, is what you're saying.
Accidents happen. Mistrials happen. Only cost me and my client a lot of time and money, but it is what it is. So the judge then said, well, I can see if we can bring another jury in tomorrow morning. And we were both just like, not wanting to redo all of this the next day, right? So I spoke with defense counsel. We got the insurance adjuster on board, and we ended up settling the case. So it worked out. We didn't have to try it again, and my client was real happy. Sweet, sweet client. He works at HEB, and he cooks all of the rotisserie chickens, which is a fascinating thing to learn about if you don't know. And I say that because, these are, again, real people I'm dealing with, right? It's cool, and that's what I love about the work I do.
Let me just tell you, we didn't plan this. I just want to say that whoever makes those rotisserie chickens is my hero.
Oh, so
because
good.
Those things are delicious.
So good.
Those things are He could have, if he had hired me, I would have taken payment in rotisserie chickens. I would have been happy to try that case for a year's supply of rotisserie chicken. I am physically, I think, addicted to those. So you please tell your client for me that I'm a fan.
I forget how many he told me that he cooks a day, but it's like 300 or 400 chickens a day. I mean, it's insane. During the breaks, during the, jury selection and just prepping for that trial, that's what you do. You just talk about what your life. I talk about, my family and my 2 daughters, and he's telling me about rotisserie chickens. And
well, can I tell you something?
Yeah.
You say that as just sort of an aside and just to give people a sense of what you're doing during a trial, some of the most important information I have ever gotten from a client or from a witness is just in that kind of casual conversation.
Yeah.
Because if you are humanizing a client, if you are extracting information or eliciting information on direct examination intended to endear that person to the jury, you are going to learn a lot more about them in casual conversation than you are in preparing them for their deposition or woodshedding them before the trial and instructing them that you have to answer the questions and don't be a smartass and don't talk back to opposing counsel and don't snap at the judge, all things that you've got to tell a witness before they testify. If you're relaxed and just having a conversation with someone, you learn a lot about them. And that is so critical to relate to a jury and impart
So important.
in a casual and friendly way.
Yeah, and if you don't like your client, that's another huge thing. If you don't like your client, a jury's not going to like your client, right? And so I've been really lucky to have over the years some fantastic clients that I personally, would want to be friends with. And back to the rotisserie chicken thing, it was during that conversation that I found out that, my client now has to wear a back brace when he's moving the chickens around, and he kept that back brace in his car. And during breaks, he would go back and forth to his car. That stuff doesn't come out when you're prepping a witness. That comes out again, during normal conversations. So
good. Well, it sounds like you got a very good result, notwithstanding, or maybe because of the mistrial that was caused by
I think so. Yeah.
the opposing party. And just to sort of fill in a little bit of that, the reason in Texas you can't talk about insurance is because this is a defense-oriented state. It's just a fact. It's look, people, and this is something that I've wondered a lot about personal injury practice in the state of Texas, is how people continue to make a living as a plaintiff's lawyer in a state in which the courts are, just as a matter of policy, the legislature and the courts, as a matter of policy, throw out as many personal injury verdicts as they possibly can, especially larger ones. This must be a conversation you've got to have with clients when they first come to you, no?
Yeah. Not so much for the car wreck cases, because those, are pretty cut and dry. But if we're talking about medical malpractice cases, which I handle as well, those are tough to get in front of a jury. There are so many hoops that you have to jump through, especially in the state of Texas.
Well, you've got to file, before you even file it, you have to have an expert affidavit, right? In a medical malpractice
you have to have
case.
a report. You have to have a report. And then, even if you've got a great report, jurors don't like people who sue doctors. People innately trust doctors even when they've messed something up. And so those cases are really, really tough. But back to, suing your own insurance company, it's really hard because not being able to talk about suing your insurance company, that is, because what ends up happening is when you are in a jury trial and I get up and I say, my client was injured and Danny defendant needs to pay for his, damages. The jury, a lot of times, thinks that individual, Danny defendant, is actually going to have to write a check at the end of the day. And that is not the case. The insurance company pays everything. So the verdicts and the judgments that come out of Texas, for example, are not always as high as other states where you can sue the insurance company directly. And you can talk about, the insurance company needs to write a check because, everyone hates insurance companies. And that's just, how it works. And so
why is that? Insurance companies are so giving, kind, and I don't understand why. What is the animus? Why do they have such a bad reputation? It's a mystery to me. You seem mystified too. All right, let's move on.
Very mystified.
I want to talk about now we've talked about all this stuff. I told you before we started I was going to ask you this question. You've had a few minutes to think about it. Now we've been talking 45 minutes exactly. How about that, Evan?
Okay.
45 minutes exactly.
On the dot.
On the dot.
Yeah.
I'm like Mr. Automatic, am I not?
Pro.
I'm a pro. So I asked, worst witness experience. Now, this doesn't mean the worst question you've ever asked, or just the worst witness. Every trial lawyer I ask this question of, what is the worst experience with a witness you've had? You're in trial. I'll tell you, while you're thinking, while you're pondering that, I'll tell you mine.
Oh, okay.
Because the whole question is just an excuse to tell you mine anyway. So
I want to hear yours.
All right. So here it is. So this was back in the early days when I was doing these misdemeanor cases. I was representing, it was a DWI, and my client was a recent college grad, young woman, 21 years old, was in fact celebrating her college graduation, leaving. There used to be, I have no idea whether this is still the case, was leaving what used to be a drag of nightclubs along Richmond out in West Houston. It used to be just nightclub after nightclub after nightclub over there, bars, all this stuff. It was just a notorious area of town, drunk drivers. So anyway, she pulls out of one of these places, gets pulled over, and my understanding was that the officer had drawn his gun on her and pulled her out of the car at gunpoint. I wasn't there. There was no video. This was long before that. And so that was what I understood about what happened. There was no evidence of it. But I thought, okay, I'm a trial lawyer. I'm going to get the cop on the stand. I'm going to make him admit it. I was a trial lawyer who'd been practicing for about, I want to say, 3 months. So clearly I had the necessary skill set to cause this officer to break down and admit his wrongdoing on the stand. So cop is on the stand, and I do not exaggerate when I say he looked like Captain America. Full uniform, bulletproof vest, close cropped blonde hair, just Steve Rogers, top to bottom, just Captain America, everybody's hero. And I, of course, the 3-month trial lawyer that I am, put him on the stand and say, now, very angrily, now you, when you arrested the person who I was representing, you never say my client. That dehumanizes them. When you arrested, let's just say Jane, when you arrested Jane, waifish, small, physically unintimidating person, when you arrested her, were you in fear of your life? Because the next question was going to be, because you pointed a gun at her. And that, in order to justify that, an officer has to say they're in fear for their life or the life of another person. What I didn't know at the time is cops are trained to testify. This is part of it. And by the way, huge fan of the police. So this is not anti-cop. He said, he looks at me, looks around the courtroom. I had just asked him very accusatorily, were you in fear of your life? And he looked at me and said, Mr. Berg, I'm in fear of my life every day I put on this uniform. Right. So it was at that point that I surrendered and she was convicted. I'm very lucky she wasn't given the death penalty after that particular performance. That was bad, but I learned a very important lesson about cross-examination at that time. And that is, know where you're going and how to get there, and anticipate everything. So that was, I want to say, the worst.
Yeah, don't ask a question, you don't know the answer to. That's something I've learned, right?
Unless you're not afraid of the answer.
Yeah, true. Unless you're not afraid of the answer. Well, that's a good one. I don't think I have anything that can top that. I'm trying to think. I mean, the last mistrial, that was rough. I would say probably the most memorable witness experience I had. I had a client that was, I don't want to say the word allegedly, because I believe she was hurt. She was hurt, injured in a wreck. That was not her fault. And it was clear it was not her fault, right? But she said and testified that she can't do a lot of household things because of her injuries, right? So during her deposition, she was asked by the defense attorney, he was asking her very pointed questions. Can you carry your groceries into the house? Can you, do you have any pets? Yes, I have a dog. Can you throw a ball to your dog? No, I can't do that anymore. No, I can't carry my groceries in the house anymore. How do you do your laundry? Well, I hang everything outside. Can you hang your laundry outside anymore? No, I can't do any of that. So she testifies, and the deposition seems to go really well. Like, she's clearly injured. Then it comes out that the defense attorney had hired a private investigator and had video clips of her doing literally every single specific thing that he asked her and that she adamantly said she could not do, which in fact she was doing, and it looked like she was doing it with no pain. So I got that little video sent over to me, and then I immediately withdrew from the case, right?
Wow. Well, that actually...
You know what? Let me just throw this in here, because people think that, plaintiff attorneys are rolling in it and greedy, and, not the case. Like, that case, I withdrew because I knew it was the right thing to do for me and my conscience and whatever. I could have stuck it out and probably gotten the insurance company to pay some sort of nuisance value, and I could have recouped my expenses. And at that time, I probably had like 10, 15 grand in expenses in the case. And I didn't. I just walked away. And that happens sometimes. And that's part of this whole, like, why do I take 40%? Because of situations like that, right? It's not a guarantee.
And that is actually exactly where I was going next, which is lawyers have an independent ethical duty not to prosecute cases that they know or should know are baseless, frivolous, harassing, or filed for some other reason that is not justified by the facts or existing law. So that is really important. And you're right. Plaintiffs' personal injury lawyers in particular have a bad reputation on this front. They are thought to make things up or exaggerate injuries or facts to benefit themselves. And again, not my area of the law, but also not my experience of plaintiffs' personal injury lawyers. Certainly not carwreckkatie.com, Katie James, who is on the podcast today. Now, we are going to move on to another topic very quickly. We've eaten up a lot of time just going back and forth. Very enjoyable, and I appreciate it. I don't want to impose further on your time if you've got somewhere else to be. You got a couple more minutes?
I do.
Okay, good. Then we are going to segue.
Okay.
We're gonna transition very smoothly
Segue incoming.
Seamlessly right on to the next thing. It's so easy.
Good job, Evan.
We're gonna talk about that's young Evan. He is a talented young man, I'll give him that. We're going to talk a little bit about politics because we know politics, policy affects the law directly. It is the basis of it all. So anyway, bit of an explanation of why I talk about this so much. First thing I want to do is, usually when I get into this, is I play clips, something relevant that happened during the week that we can address and relate somehow to the law.
Okay.
I think we can do both, but first I have to take, this is sort of, this is a point of personal privilege, I think, since it is Geoff Berg is litigious and I am, in fact, Geoff Berg. I want to take this point of personal privilege. Well, what I want to do is play this and you can thank me in advance.
Okay.
You, Katie James, carwreckkatie.com, you just get your thanks ready. Play number one.
Ted will admit that. I've been right about a lot of things that a lot of people said, no, that won't happen, but a lot of bad things happened, and some good things I've been right about too. And I only want to be, so I'm not going to call this as a prediction, but in my opinion, the Jewish people would have a lot to do with the loss if I'm at 40%, if I'm at 4, think of it, that means 60% are voting for Kamala, who in particular is a bad Democrat.
All right, so we are responsible. You're welcome. You are welcome.
Yeah.
That is apparently our doing. If he loses, it's the Jews' fault. Like, we don't have enough going on. Yes.
I mean, I don't want to rehash the debate, right? How many weeks ago? Was that a couple weeks ago?
Feels like several years ago, but it was just a couple weeks ago.
But the whole, I've got concepts of a plan. Oh my goodness. I mean, I as soon as he said that, I texted a friend and I said, that sounds like when I was in the 5th grade and I had a science project due, and it was 5 p.m. the night before it was due, and my mom asked me about that science fair project, and I had to say, well, I've got concepts of a plan, but we're going to have to come up with an entire, science fair project in the next 4 hours before I have to bring it to school in the morning.
With all due respect, I would, if it was a choice between 5th grade Katie James and existing current Donald Trump, that is not even a difficult choice.
Yeah.
Because we know that 5th grade Katie James has better judgment and is smarter than existing current Donald Trump. Let's talk about this, because I don't know about you. I don't think we've ever had this conversation. I'm not a big Second Amendment person.
Okay.
I don't love the Second Amendment. I don't love guns. I'm not a gun person.
Yeah.
Plenty of people I know have guns, use guns,
Right.
love guns, fetishize guns, probably love them a little too much, from what I can tell, in my view.
Yeah.
Not my thing. Okay.
Totally fair. Yeah.
I don't judge. My candidate for president disagrees with me
Right.
on this particular point and agrees, I believe, with the vast majority of Americans who, to one degree or another, really do like guns. We've spoken on a previous episode of this podcast, which, Katie James, I'm sure you've heard, so we'll just refer back to that. Thank you for listening, by the way. The Second Amendment, what it says, what it actually means. We've gotten into that at length, at some length. Young Evan is now a Second Amendment scholar. The history of the Second Amendment, the meaning, the words behind it, what it all is supposed to do. Am I wrong, young Evan?
I've got some knowledge on the Second Amendment thanks to this podcast, I would say.
See?
Yeah, I've learned a few things.
We're here to light a candle rather than curse your darkness. So here is something I don't understand why, because I don't love the Second Amendment.
Okay.
But Donald Trump's supporters are supposed to be big fans of it. In fact, have threatened to take advantage of the protections it provides in order to remedy the outcome of an election that they think was stolen from them. But Donald Trump was out promoting this clip, which I thought, are you trying it just as you humanize and make relatable a client in front of a jury? Kamala Harris, play number 2.
Okay.
This is her talking
I'm a
openly.
gun owner. Tim Walz is a gun.
I did not know that.
If
And I thought
somebody
that was
breaks in
powerful.
my house, they're getting shot.
Yes, yes. I hear that. I hear that.
Probably should.
She says somebody breaks into my house, they're getting shot.
Right.
How does that? First of all, I don't like this celebration of guns. I don't think that's what the Second Amendment does or should do. But she's saying I'm a gun owner, and if somebody breaks into my house, they're getting shot.
She sounds pretty relatable.
It does to
Right?
me, right?
Yeah, she sounds like a real human, a real person.
A real person, which is what
Yeah.
you want in front of a jury.
What you want. Like there are, kind of segueing this into lawyer stuff, but there are schools and CLEs that you can go to that just teach you how to learn about yourself. Because if you know yourself and, know your soul, you're going to be better in front of a jury. And I've done some of that stuff, and it's true. Like, if you are comfortable in who you are and you aren't afraid and you aren't nervous, juries are going to pick up on that, and they're going to love you for it.
Exactly
Or at least
right.
like you. Yeah, and that's
That is
huge.
perfect. By the way, CLE, continuing legal education for the
Yeah.
non-lawyers or non-compliant lawyers. who may be listening. Katie James, this has been exactly an hour, 1 hour and 6 seconds. Evan, come on, who's a pro?
I mean, podcasts can be however long you want them to be. I mean, it's not a big deal.
I'm a
but
schedule guy.
I'll give you some props. This is impressive.
That's timing. That is what you call timing. Katie James may be found at carwreckkatie.com. She's got an office in Houston, in downtown Houston, a great firm of personal injury attorneys. And she is, I'll say it again, an outstanding trial lawyer who I have seen at work and can attest personally. I am Geoff Berg. This is Geoff Berg is Litigious. BergPC.com. That's Berg, B-E-R-G, PC.com. I want to say thank you once again very much to young Evan Shearer, the producer of this program, and of course, the big boss, Scott Braddock, executive producer. Go back if you haven't heard it yet. Go back. Listen, you thought I was kidding. We did have Dan Aykroyd on this podcast. He was on last week. It is the episode just before this one. Go back and listen to it. An amazing story, an incredible story of a Perry Mason-like trial that actually happened. Dan Aykroyd tells the story. Fascinating. All right, I'll see you next time. Bye.